Привет из Дубая! С вами передача «ГолубьМира», где разбираем крутые навыки. Спрашиваем на английском, отвечаем на русском. Подтягивайте язык или смотрите перевод в тайм-кодах. Let's talk about Shareholders Agreement and let's start with the definition.
When you start a startup or enterprise or some company limited liability, you think that everything will go well and you never will sell something, you will never will quit, and your business will just grow up. But in reality, everything is much harder. So sometimes you will need some special procedures, and if you will not write it down before you make this enterprise running, you will have problem. I have been working for 20 years for hugest Russian financial group, and I have learned that all my shareholders, they wrote a lot of different papers before they start the business. And the reason is, if you will not write it down, you will write it with your blood.
And when we're approaching to this document or maybe like a set of the documents, what might be the main parts that we will need to consider when we try to come up with the idea, like what exactly we want from it and how we will be executing upon it?
I have been writing a shareholder agreement seven times for my businesses and 2 times for businesses of my client. And when I was making it for the very first time, I was thinking that this should be like an agreement, which is quite commonly used by the law of my country. But suddenly I got a call from my partner and he was talking with me for a very long term. He was American guy, and he explained me that shareholder agreement, this document which should be additional to state documents. So everything which could not be regulated by my country should be written there, and we will make this by English law and law of wealth. And when I realized how it's work, it was very funny. So I have not to go to court in my country, but I could make it abroad if I will have this. So I will show to the state just documents which is signed by Notary Public and some other state institution. But if we will have something more complicated, we will go to quarrel in English court.
We probably could slightly dive deeper in terms of like who are the actors, because obviously we mentioned shareholders, there might be some government bodies or institutions. So who else might be involved into writing, reviewing, executing, or being and the person who is mentioned in that document?
It is not necessary or even imprudent to write this document with some people from the state bodies. It is much better to use advocates or some other lawyers who work abroad for hugest firm, and I have learned that better to use English law firm to make this document running, and they just do it. So usually it's work like you and your partners, you hire a law firm. For example, you will hire one firm, I will hire another firm, and if you have any quarrel, we will ask our lawyers to make an agreement between them without involving us in this dispute and in the discussion. And you know, it's very funny. When I was working in Alpha, some of my shareholders sometime were thinking that it is time to start a fight, and they just were sitting all together and they just make calls to lawyers and say them start something like this, and everyone was knowing which order was given. And after 2 or 3 weeks, it was a paper which was signed by several law companies, and they were saying in the fight during 3 weeks we have found several solutions which will suit all of you.
I remember probably at one of the skills or maybe at one of the previous discussions, you mentioned the moment you enter or step in certain relationship, actually think how they will end. And endings also could be different. It's not only like a good one or bad one, but you know, like maybe something in between or maybe something that you may not even suspect. So how you as the shareholder, given that you have some sort of like a part, you own part of the company or like part of the assets, like what kind of things you need to consider in order to make sure that, you know, like your interests actually being considered and it will be done to your benefit?
first you should think what will happen if you will die. You know, it's very funny. When you are young, you never think about this. But if you will die and you have children or grandchildren and maybe some other kind of kin or relatives, you should think how they will live, because they used to spend a lot of money because of your business, and they fly in business jets. They used to have a vacation on Maldives and so on. So you should write, even in shareholder agreement, special items. For example, if I have like 50% in the company, if I will die, okay, I will give 10% away to my partner, but in exchange of this, he will supply my company with this 40% of the company, for example, for 10 years. Then it would be reduced 10% more, and so on, until my partner will die, or until all of my shares will go to him. Or for example, if we want to split, it is very hard. For example, we have business all together with you, and suddenly you will say to me that you have some divorce and you have some problems, maybe you have some illness, and you kindly ask me to give half of the company in liquid form, in form of money, and you will quit. Even maybe you have 50% and you will say, okay, give me just 30 and I will go away. But it could be that I have no money, and you know, it's very hard. For example, maybe we need an investment, I don't know, small sum, but if we will start to make it this investment, I will give my half and you will not. So everything will go to a strike. So we will block each other. So it also should be written in the shareholder agreement.
And when it comes to the situation, let's say like when, like there are some arguable parts, let's say something was not really considered, obviously they would bring it to the court. So how to try to maybe even extend the, like your thinking, and think of what else may not be considered, or like what is this unknown that I might have in my business, so that I can't really foresee now, but at least I have some sort of like a, like insurance, or like something that would let me catch this like issue, so I could use it as a fallback.
When I was working in McKinsey in Frankfurt on Main, it was like 31 years ago. When I arrived to the company, I was asked to sign a document. It was named NDA, non-disclosure agreement, and it was in a very small font on 18 pages, double side. You know, when I was start to read, my English was so poor, but I realized that there are so many items. For example, what will happen if I will die? Who will get rest of my salary, and so on. So in this shareholder agreement, you also should understand that if something will go wrong, it should be written. For example, in my latest shareholder agreements, we even write what will happen if some partners will go under sanctions, if some partner will go to the court. So we give to each other, I don't know how to say it, доверенность, I forgot how to tell it in English.
Probably NOC or power of attorney.
Yes,
power
of attorney. Yes, correct. Power of attorney. So we give each other power of attorney and so on. By the way, I give some power of attorney to my wife, to my sister, and all my partners know about them. But this will work just if I could not be on a line or in a touch for 72 hours.
Well, and then my last question actually would be like how knowing about the shareholders agreement could help to make this world a better place.
Maxim, to be honest, I have been starting 7 businesses before I came to Russia, and just 4 of them ended well. Something was sold and I got a profit, and 3 was total disaster. And each time it was a very hard lesson. One partner of mine was killed. One company was, I don't know how to say, taken away by raiders. And one company was closed because of pressure of the state. I couldn't resist at this time. And when I start the same projects in Russia, now I have 3 of them, and maybe I will start 2 more. I write shareholder agreement, even if I am a single owner. And the reason why, because I do not want to go to court. I want everything to be written. You know, if you have some agreement with someone and you will go to notary public and he or she will take a signature on it, then it is not necessary to go to court. So everything would be in force immediately.
Вступая в отношения, подумайте о том, как вы будете из них выходить. А мы рассмотрели навык соглашения акционеров и чем он полезен именно вам. Всем мира!